The next matter to come before the court this morning is Caliber Home Loans versus Timothy Puin. Both sides will have 15 minutes to argue. The appellant may reserve up to 5 minutes for rebuttal. If you are the appellant and wish to reserve any time for rebuttal, if you let me know when you get started, I'm keeping the clock this morning and can keep you apprised of the passage of time. We've read the briefs and we are ready to proceed when you are.
Thank you, Your Honor. Good morning, Your Honors. May it please the court, my name is Timothy Puin. I am one of the appellants in this matter, and I represent appellant Sarah Puin.
Mr. Puin, are you a legal counsel?
Yes, I am admitted before the Supreme Court of Ohio.
Thank you. Thank you. And would you like to reserve any time for rebuttal?
Thank you, Your Honor. Appellants would like to reserve 5 minutes for rebuttal. Your Honors, since Schwartzwald established that both an interest in the note and the mortgage must be established at the time of the filing of the foreclosure suit, this court has adopted long-standing precedent, irregardless of the holding of other districts, that one or the other is sufficient. In this case, at the time, Caliber Home Loans and Capital E was substituted in for Chase as the party plaintiff. They did not establish that they held the note or a chain of assignment to the mortgage. As with the bank in Schwartzwald, they didn't establish either at the time they came into this case. At the time of the summary judgment affidavit, Caliber established it held the note, although we argue the affidavit was insufficient on that point, but they did present the note at that time, Caliber did. They still did not show a proper assignment of the mortgage. After the judge looked at the summary judgment briefings, the trial court held what it called an oral argument. At that oral argument, Caliber flew in a witness from San Diego who had not been disclosed to us to testify that Caliber held the note and had a proper assignment of the mortgage. This was at oral argument after briefing had closed, over our objection. The magistrate's decision is explicitly based on the hearing and the evidence deduced therein. The transcript is before the court. And the trial court adopted the magistrate's decision, which finds that there was a valid assignment of mortgage. Caliber filed a motion to intervene as the party plaintiff in this case, stating that it is the current holder of the note and mortgage which are the subject of this foreclosure action, as is evidenced by the assignment of the mortgage attached as Exhibit A. So the original plaintiff was J.P. Chase, which established that it held the note and the mortgage. However, J.P. Chase was substituted in for the proper party plaintiff by Caliber. Now, the trial court granted Caliber's motion to substitute in within 14 days. In other words, we did not have a chance to review and oppose the motion to substitute party plaintiff. It was granted within 8 days, I believe, of the filing. Now, contrary to what Caliber said in its motion to substitute in, it did not present any evidence that it was the current holder of the note at this time, none whatsoever. And its purported evidence that it was properly assigned the mortgage is insufficient as a matter of law. It's attached, Exhibit A, to its motion to come in. It was not a recorded assignment. It was an assignment from Caliber to Caliber as attorney-in-fact for the original plaintiff, J.P. Chase. So this assignment that they submitted is not assignment from Chase to Caliber, it's assignment from Caliber to Caliber. J.P. Chase by Caliber as attorney-in-fact. By power of attorney to be recorded herewith. Okay, no power of attorney was recorded. The recorder refused to record the power of attorney. It was insufficient as a matter of law because it did not identify our property. There is no evidence in the record to this day that Caliber has authority to foreclose on our property in particular. And that's seen quite clearly in the affidavit filed in support of summary judgment. Now this affidavit states, Caliber's affidavit states that they have reviewed business records. Fair enough. We made the point they haven't stated they've reviewed original business records. Okay? Even if we accept that they've reviewed original business records, the attachments to the affidavit are insufficient to establish their right to judgment as a matter of law. Now this issue was addressed squarely by this court in October of last year in the case of Deutsche Bank versus Dvorak, wherein it was stated that the homeowner's argument has merit to the extent that the affidavit is averring to the content of business records that aren't attached to the affidavit. That's exactly what happened here. The affiant states that Caliber is entitled to the mortgage by way of a valid assignment, but the documents that would support that are not attached. In particular, what is missing is a bulk loan servicing agreement that laid out a number of properties, presumably. That document is not in the record, was not presented at oral argument, quote unquote, after the close of briefing, is not in the record, nobody's seen it. Now that document purportedly, supposedly, would have our property listed in there among who knows how many others. That's not before the court. So the only authority to take the assignment of mortgage is in a document that's not before the court, not attached to this affidavit. So this affidavit is insufficient as a matter of law. So Caliber did not show that it had the note in the assignment when it came in the case. Further, at the time it came in the case, the deadline under the power of attorney it presented a copy of the power of attorney. The deadline had passed at that point by the time it came in the case. The power of attorney Caliber presented says this power of attorney is pursuant to a bulk servicing rights purchase agreement. Okay? And that's not in the record. That bulk servicing rights purchase agreement is not in the record. Our property is not mentioned in the power of attorney. All we have is the bare assertion by Caliber that they have a proper chain of assignment here. They don't. It hasn't been shown to this day that they do.
So your challenge is not to the individual who signed the affidavit, whether or not that person has knowledge of what they're purporting to assert, but rather that the documents on which they were relying are not before the court.
Correct, Your Honor. Caliber had a third opportunity to get it right, and the trial court afforded them an opportunity to have an evidentiary hearing after briefing had closed. And in the order for that hearing, the trial court said it wanted to see the note and mortgage. Didn't say it wanted to see the assignments, they wanted to see the note and mortgage. We objected and we asked for clarification on the record. We said, is the court ruling on summary judgment? What is the court doing here? Are we entitled to bring witnesses? Who are they going to have? Is this a trial? What's going on? This hearing was held within a week or two after briefing closed. Now, at this hearing, Edward Asher, a Caliber employee, I suppose, I don't know, from California came in and held up a copy of the note, he held up a copy of the mortgage. He still did not establish that the mortgage was properly assigned. And Caliber's rebuttal to that is, we don't have to do that because the mortgage follows the note. But it doesn't. What that means is that the person who holds the note has priority over all others in foreclosing on the property. It only makes sense that the purchase money mortgagee would have the first claim to foreclosure. If we defaulted on a credit card, they shouldn't be able to foreclose over Caliber. That's all that that means, but that's not the law in this district anyway. The restatement of the law of property says that it should be the law that the mortgage follows the note without showing a chain of assignment. That's what the restatement says. And the restatement cites an Ohio case from 1895, which I believe showed up in Caliber's brief. 1895, a Supreme Court case. That was involving probate court, where two different people had the note and the mortgage. Now, I would respectfully submit that that concern is still valid today with Washington Mutual, other banks, notoriously splitting their interests in property. Here, the reason for that law, that you have to show a valid assignment, is valid because as of last month, Chase filed something in this court. Chase, the original plaintiff, filed a notice of appearance in the trial court. Not Caliber, Chase. So this is why the law requires a valid assignment. The 1st District and the 9th District are very clear about that. I believe Counsel for Appellee practices in the 1st District. This case is in the 9th District. And yet Appellee is arguing case law from 1895 doesn't apply in this context. Arguing law from other districts or from the state. In this district, it's clear you have to show the time you foreclose, you have an interest in the note and the mortgage. To this day, that has not been done.
And Counsel, just now reaching that 5 minutes, you may proceed or reserve as you wish.
Thank you, Your Honor. We'll reserve time.
Good morning, Your Honors. May it please the Court, my name is Bill Pertell. I represent the substitute plaintiff, Caliber Home Loans. And what this case comes down to is no one is disputing that Chase held a note of mortgage at the time this case was filed. That issue is not before the Court. It's never been argued by Mr. Puin. In fact, the first argument Mr. Puin made was that Chase has to go because Veracrest has my loan. It's a motion to dismiss filed in the trial court case that says Veracrest has my loan. Get JP Morgan Chase out. So we filed a substitution plaintiff, showed the assignment of mortgage, showed the limited power of attorney and everything else. And now we have an objection. Whoa, whoa! They said Veracrest, who is now Caliber, is my lender, but I didn't really mean they had my loan. I just meant I didn't want Chase to foreclose me. But Mr. Puin has never said who should foreclose him. Caliber says they should foreclose him. They signed an affidavit saying we have the original note. They did bring one to a hearing to show the court they have the documents. And Mr. Puin says, well, I checked the recorder's office. And the recorder says they don't know anything about this. Well, the 9th District in Bank One v. Dillon back in 2005 said the recorder's office is not the gatekeeper as to validity of business transactions. Notes are sold under the Ohio Revised Code every day. Nobody has to record it. Great business deals, mergers, acquisitions happen. The recorder is not asking for permission. The same way when a loan is sold and an assignment is executed, that is a deal between the parties. The evolving case language started in the 6th Circuit federal courts, moved over to Ohio's district courts, Bank of New York versus Unger, I cited in the brief. The 9th District has its own version. Basically says, between parties, when they sign agreements between themselves, it's binding. When Chase granted a limited power of attorney to Veracrest, which is now Caliber, that was binding as soon as it happened. Otherwise, it's not even worth the paper it's written on. But that power of attorney is valid and proper. And I cite a case law in my brief that says, once again, the recording of that document to make it a public notice is not what is privately binding between the people who actually signed those agreements.
Well, but to Mr. Putin's point, how does he protect himself against multiple claims by parties who believe that they have an interest, which is what the Ohio Supreme Court addressed in Schwartzwald?
I believe Schwartzwald was about access to the court. Did you do enough to invoke the court's jurisdiction? And once Chase did that, now you do what judges do every day. You look at the law, summary judgment's de novo, so your honors get a free crack at this issue to say, did Caliber come forward and show that it is the party that holds the note? Mr. Puin, as he's done very skillfully, has opposed it. He has invoked the mechanisms of the court, the burdens of proof, legal arguments, and everything else, and in the end, the court made a decision that says, okay, there could be 1,000 people claiming this note. Do I trust that Caliber is the party that actually holds it? And their affidavit says clearly, yes, we have this loan. It's ours, in our possession. Look, here's a copy of the note from our business records. I personally reviewed those business records. I know how they're kept. I know how they're created. I know everything about this loan. Yes, I have this loan. Mr. Puin has not debated that. He said we didn't record an assignment. Okay, well, where's the note? Not one affidavit, not one piece of evidence filed during the briefing challenges Caliber's possession of the note. Instead, the only evidence in the record is that Caliber did not have the recorder's stamp on the limited power of attorney, and that Caliber's private business agreement, that loan servicing agreement, was not attached to the limited power of attorney. Revised Code 1337.04 doesn't require that to be attached to the limited power of attorney. It says for a third party not Mr. Puin, but a bona fide third party who comes with no knowledge of this transaction will be put on notice by the recording of the power of attorney. But it doesn't say a power of attorney must then also document every single thing it references. It's never asked for in evidence. I mean, the power of attorney stands as it is. And under Kernahan versus Mance, yes, an 1895 case, if you shepherdize that case, or Quayside, or whatever your honors prefer, it's a green case. It is cited everywhere, over and over and over, because this is real estate. Nothing really has changed much since the 1800s on this issue. The recorder's office serves the function of getting notice to the public of people who are strangers to this transaction. Mr. Puin is not a stranger. He's the first one who stood up and told the court, Veracrest is my lender, get rid of Chase. Mr. Puin is the one who could have said, I made my mortgage payments. He's not debating that he is in default. His sole answer is a third party that is not me, not the plaintiff, and not the court, may take an interest in property without bona fide knowledge of Caliber's interest. That's not what the court requires. In Ray Estate of Alt was quoted in my brief, once again saying recording is not validity. It does not determine what the parties do between themselves. I can refer you back to Bank One versus Dillon, where the 9th District looked at this matter and said, we want to reach the truth, not the truth about what a title examiner would find if they bought the property as a bona fide third party, but if I'm a judge looking at an affidavit, and Mr. Puin's testimony says Veracrest has my loan, and Caliber includes a business document showing that they're the successor to Veracrest, that they have a copy of the note, that they've compared it to their business records that rely upon in the ordinary course of business, they meet the authentication requirements of the evidence rules, and everything is there, which I believe meets the 9th District case law standards, the Lava case, lots of others, that this looks right on its face. There's no real challenge to that. The only challenge is at a hearing, you made us produce the original, which we'll concede. I don't really think that's proper for summary judgment. I don't think it was necessary for summary judgment. If the trial court wanted to establish the facts for itself, that's fine. On de novo review, you can discard it. I would say look at the evidence. Going into that hearing, it's a battle of we have the loan versus the recorder doesn't know that. And when it comes to Caliber versus the recorder's office, Caliber wins. Because Mr. Puin has not said Caliber doesn't own my loan, doesn't say I'm not in default, doesn't say this limited power of attorney may or may not be valid. He conducted no discovery on that, has no Rule 56E evidence, has nothing other than it wasn't attached. Okay, it's not attached. It's, once again, not necessary for a power of attorney to list all that. It says, by reference, here are the loans. Caliber relied on that. Caliber said, we have this loan, whether the power of attorney was forged or not. That is an issue between Caliber and Chase. And Chase hasn't come back in to say, whoa, that's my loan. Give it back. Caliber's not supposed to have that. No, Caliber has been consistent on who holds the loan, who holds the note. And by holding the original note, which it did produce when asked, I mean, there's a trial court in Summit County has a certificate that you file at the beginning of a case that has to be a statement that the plaintiff, upon demand, can produce the note. Of course.
What's the import? I'm sorry.
I'm sorry, go ahead.
What's the import of the bulk loan servicing agreement not being attached to the documents that were filed in this case? So going to the specific property.
In the industry, in the mortgage industry, that's their secret recipe. How much they paid for the loans, what loans are being transferred, how big their market share is that they're transferring. They really don't like making those public because that's their private business dealings. So they'll make reference to it in the power of attorney so that the parties can police themselves in the transaction. So it is common practice, and it's been cited in multiple courts across Ohio. I don't have the sites in front of me, but I can find them, that these bulk sale agreements, these purchase and sale agreements, PSAs are what they're commonly called a lot of times, aren't generally made public unless someone requests it in discovery and then, okay, we'll turn it over. But that's the business model that our clients try to get a competitive advantage on. How can they buy and sell pools of loans at a profit? It's a business. But at the same time, that's between Chase and Caliber. And Caliber ended up with the original loan.
It is and it isn't. I mean, from the standpoint, I understand your client's business model and their efforts to obtain a competitive advantage, which is what they do, but this is the Puin's home. And the question is whether or not the I's are dotted and the T's are crossed, and whether or not their property would show up in this bulk servicing agreement. What if it doesn't?
I don't think that issue was before the court. The Puins did not say Caliber doesn't have my loan. They said the power of attorney was unrecordable because of that defect. They stated Veracrest has my loan in their motion to dismiss. They have not ever challenged that Caliber actually has their note. And if Caliber, hypothetically, was a thief, broke into Chase's office and stole the note, under the Uniform Commercial Code, Caliber still wins. It's not a question of dotting I's and crossing T's. Caliber has done that with its evidence. Mr. Puin has not challenged that part of the case. Mr. Puin has picked the recording statutes to launch his challenge, which is not what a homeowner does to challenge a foreclosure. If he said, I don't think Caliber has my loan, I don't think Caliber has the original note, I don't think that this affidavit is proper, he has to come up with some evidence of why, other than I read the affidavit and I just don't like it. Now, the court can read the affidavit and see if it falls short of the evidence standards, but in my brief, I walked through what parts of the affidavit matched the thing. The affiant stated their position, their legal title, the kind of business knowledge they have working at Caliber, their authority to execute the affidavit, their comparison of the business records against the attachments to the affidavit. The attachments go through the waterfall of being in possession of the note with an assignment of mortgage, with an executed limited power of attorney, with a business merger doctrine showing they're the successor to Veracrest. And at that point, Caliber's status as the holder of the loan was not further challenged. Caliber's recording of an otherwise valid assignment of mortgage is what is before this court, and I don't want to distract the court from that point, because I think that truly is the issue that makes the evidentiary hearing moot, that makes, by the own law of the 9th District, a challenge to the recording statutes moot, because in the end of the day, Caliber still has this loan, and that evidence has never been controverted. So with that, I have no other arguments to make, but I'd be more than happy to answer questions if the court has any. Thank you, Your Honor. Excuse myself.
Thank you, Mr. Patel. By way of brief rebuttal, with all due respect, that's a straw man argument. We've not premised our case on the lack of recording of the assignment of the mortgage. In fact, Caliber went back to court after summary judgment had been granted, went back to the recorder. They went back to the recorder and they recorded another assignment of the mortgage. This is not the one that summary judgment was premised on. This is public record. This is from the recorder, recorded 11/12/13. That's after summary judgment was granted. They went.
Is that in the record before us?
What's in the record in my brief is the fact that this was done. This was not in evidence at the time of summary judgment because this came after summary judgment.
We can't consider.
Understood. The point I was trying to make is this is a straw man argument. It's not Caliber versus the recorder. It's the insufficiency of the assignment, the failure of Caliber to show the proper chain of assignment. It's their burden of proof. They're the plaintiff. They have to show standing when they come in the case. They have to show entitlement to summary judgment. The fact that the bulk loan servicing agreement was or was not requested in discovery, and I don't concede that point because we tried to conduct discovery in this case, the fact that that wasn't produced in discovery does not give it a free pass to not produce evidence it needs to prevail as a matter of law. It still has to prove its case. We didn't default in this case. We filed an answer. We defended ourselves. They have to put forward sufficient evidence to show entitlement to judgment as a matter of law. It's their burden, not our burden.
But you have to establish, or at least point to, the absence of a genuine issue of material fact.
Understood. At the time they came in this case, they did not show they had a note. That was not attached to their motion to intervene, to come in as party plaintiff. Judge granted that motion without any opposition. At the time of summary judgment, they still have not shown a valid assignment. I think counsel glossed over the fact that he has to show a valid assignment. It's not about being recorded or not recorded. It's about, is this a valid assignment? The fact the recorder rejected it out of hand is evidence it's not valid, but that's not the evidence we rely on. We rely on the face of the assignment. As Judge Moore pointed out, there is no evidence in the record that our property is subject to the power of attorney. Why even file the power of attorney if it's unnecessary? The fact that we don't contest possession of the note is inaccurate. The note was established to belong to Caliber at an evidentiary hearing after briefing was closed on summary judgment. The trial court explicitly relied on that hearing and explicitly stated in the magistrate's decision that was adopted that Caliber showed it possessed the note at that hearing. In asking for the hearing, the trial judge said, I want to see the note. I want Caliber to show me the note of the mortgage. In other words, the trial judge recognized implicitly that the evidence before it was insufficient as a matter of law. It should have overruled summary judgment and proceeded to trial, at which Caliber could present a properly recorded, a properly executed assignment, I should say, that was in fact recorded, and it could also present the note and the mortgage. It could present it to a witness from San Diego at that time. This is a classic trial by ambush. I have researched and have not found a clearer case of summary judgment by ambush, evidence being presented after the briefing had closed, and a so-called oral argument, where a witness that was not disclosed from us flew in with documents that were not produced to us before the hearing. If the court looks at the transcript, that witness admitted that the note he presented at the hearing was different from the note attached to the affidavit of Ms. Jurido. He admitted on record those are different. Now, the magistrate said those differences were de minimis and don't preclude judgment. But the fact is they were different. And we didn't see them.
Has conceded that it was improper for the court to rely on issues that came up after.
And Judge Moore, that reason in and of itself is enough to overrule summary judgment, because the trial court relied on that hearing in its summary judgment ruling. Summary judgment on that basis alone, our second assignment of error, was improper. Caliber's fallback argument is, we admit the hearing was improper, but we were entitled to judgment anyway. If they truly believe that, why did they fly in someone from California with documents that hadn't been produced or put on the record yet? Why did they do that if they really think the hearing wasn't necessary? Why didn't they agree with us that the hearing wasn't necessary? They didn't. They came in and tried to prove that case at that time, and they still failed to show chain of assignment. That is a bottom line requirement in the 9th District and the 1st District, and frankly in Schwartzwald. In Schwartzwald, the plaintiff didn't have either the note or the mortgage. Well, when Caliber came in this case, it didn't show it had the note or the mortgage either. And to this day, it has not shown it has the mortgage. And we would argue, its affidavit on summary judgment was insufficient to show it had the note. But that's not our argument. After the evidentiary hearing, it showed it had the note, but that evidentiary hearing was improper and should not have been considered by the trial court. And with that in mind, we'll rest unless the court has any questions. Thank you, Your Honor.
Thank you, counsel. Thank you both for your presentation this morning. The court will take the matter under advisement and issue a written decision which will be mailed to both sides and posted on the Ohio Supreme Court website, which you can link to from our website. Thank you.
Thank you, Your Honor.
Thank you.